we're going to start the concept of the bailment today. So, hi everyone, we're going to start the topic of the bailment today. And in the concept of the bailment, we are going to learn. This is actually, we are dealing with chapter 9 of the Indian Contract Act. And before this, we have completed all the other portions of the contract. We have understood what is the rights and liabilities of the agent, what are the duties of the agent, what are the duties of the sub agent, how the concept of the agency works, what is a lease, what is the gift, and how the transfer of the gift is being done. And we have also understood how the contract is made, what is the nature of the contract, and we have also understood along with that about the right of the person who losses the injurious the damage, and we have also understood about the master servant relationship and the principal agent relationship, and we have studied what is a contract, what are the terms and conditions of the contract, what is a void contract, what is a voidable contract, and what is a valid contract. So we have understood all these concepts in details. Okay, so now this is a point where we are studying about the chapter 9, and as we have discussed all the other portions of the contract, this is the last part or last chapter of the Indian Contract Act that we are studying right now. So when we are talking about the concept of the bailment, okay, so Indian Contract Act of this chapter 9, this deals from section 148 to just 1 second, let me check. Yeah, 148 to 181. Okay, so we have understood that on this chapter 9, this deals from 148 to 181 of the Indian Contract Act. So when we're talking about the concept of the bailment, what do we understand by bailer, bailee, and bailment? Okay, let's understand this bit by bit. So according to section 148, a bailment is a delivery of goods by one person to another. Delivery of the goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. The person delivering the goods is called the bailer. The person to whom they are delivered is called the bailee. Okay. So when we are talking about this concept of the bailment, it means bailment is the giving of goods by one person to other person for a specific purpose under an agreement. Okay. For example, I am giving you a specific thing of mine, that is called the bailment. When I am giving a specific good of mine to you for a specific time period, okay, that is called the concept of the bailment. When we have discussed about the concept of the lease, under the concept of the lease, we have discussed the lease is also delivering of the property from one person to another for a specific time period. But we have understood that whenever we are talking about the lease is about the transfer of the immovable property, the property which cannot be moved. When we are talking about the lease, it was the transfer of the land, transfer of the house, transfer of the property which are immovable in nature. Got it? And whenever we are talking about the bailment, this is the transfer of the movable property, the property which are movable in nature. So bailment is the transfer of the movable property from one person to another. Okay. So whenever we are talking about the concept of the bailment, it means giving the goods by one person to another person for a specific purpose under an agreement. For example, I am using this watch of Titan. Okay. So I am giving this watch to you for the duration of 3 months for a specific purpose. Okay. That is called the concept of the bailment. It depends that what is the purpose, for what purpose I am giving you that specific thing. Okay. For example, I am giving you this watch for the duration of 1 month for the purpose of repairing it. This watch is having any defect, and I have just informed you, or I have introduced you to repair this watch. I requested you, please repair this watch and send me back. Okay. So as I have given this watch to you for the specific purpose of repairing it, this is the mutual agreement between you and me that yes, I am giving you this watch for the purpose of repairing this watch. But when we are talking about the concept of the lease, under that we have understood that was about the specific transfer of the partial ownership or possession of the property. In the lease, specifically, it was based on the immovable property, and secondly, it was about the transfer of the immovable property with the specific amount in return. For example, I have taken certain lease from you. I have taking a land from land as lease from you. Then in return, I have to pay the specific price of the land to you. It is not possible that I will take the ownership of the land, or I will enjoy the possession of the land, and I will give you nothing in return. This is not possible. I have to give something you as return when this comes about the concept of the lease. And when it comes about the concept of the bailment, it means it is the transfer of the specific thing by one person to another person for a specific purpose according to the terms and conditions of the agreement. And about the consideration of the agreement or the consideration of the contract, it is not fixed in nature. It depends upon the mode of the contract, upon the nature of the contract, that what is the primary purpose of the contract. What is the primary criteria for which the one person is giving a specific good to another person. ऐसा कौन सा चीज है जिसके लिए द फर्स्ट पर्सन, पहला इंसान, दूसरे इंसान को वो चीज दे रहा है या दे रही है, उसका जरूरत क्या है, उसका मोटिव क्या है, इंटेंशन क्या है, वो सामान जो दे रहा है ना, उसका कौन सा मकसद से वो सामान दे रहा है, दैट डिपेंड्स अपॉन द कंसिडरेशन. क्योंकि फॉर एग्जाम्पल, आई हैव गिवन यू माई वॉच फॉर द पर्पज ऑफ रिपेयरिंग. अपना ये घड़ी मैंने आपको रिपेयर करने के लिए दे रही हूँ. इफ आई एम गिविंग यू फॉर द पर्पज ऑफ रिपेयरिंग, देन यू विल रिपेयर इट एंड रिटर्न टू मी. सो यहाँ पे who will take the consideration? You will take the consideration because in the agreement मैं आपको अपना घड़ी दे रही हूँ to repair it. इसका काम करने के लिए मैं आपको दे रही हूँ. So you are liable to get the consideration amount from me. घड़ी के रिपेयर करने से बदले जितना भी कंसिडरेशन अमाउंट बनेगा वो किसको मिलना चाहिए? आपको मिलना चाहिए, बिकॉज यू रिपेयर्ड इट. सो यहाँ पे इट इज द कंप्लीट नेचर ऑफ द बिल, the property of it is completely the nature of the good, that सामान क्या है, किस वजह से, किस रीजन के वजह से ये जो सामान है, ये जो गुड्स है, उसी को दिया जा रहा है. समझ रहे? So bailment means giving the goods by one person to the another person for the specific purpose under an agreement. एक एग्रीमेंट के तहत अगर कोई पहला इंसान दूसरे इंसान को किसी भी तरह का सामान दे रहा है या दे रही है, दिस इज कॉल्ड द कॉन्सेप्ट ऑफ द बेलमेंट. द फर्स्ट पर्सन जो सामान दे रहा है उसको बोलते हैं हम बेलर, एंड जो सामान ले रहा है उसको बोलते हैं बेली. Once the purpose is done, the person who is giving is called the beller, and who is taking the specific good is called the belly. अगर यहाँ पे मेरा जो वॉच है, मैं आपको वो वॉच 1 महीना के लिए दे रही हूँ टू रिपेयर इट, दैट मीन्स आई एम द बेलर ओवर हियर. क्योंकि मैं यहाँ पे बेलर बोला जाऊंगी क्योंकि मैं आपको अपना वॉच रिपेयर के लिए 1 महीने के लिए दे रही हूँ. एंड यू आर द बेली बिकॉज आप यहाँ पे मेरे से मेरा वॉच एक्सेप्ट कर रहे हैं फॉर द पर्पज ऑफ रिपेयरिंग इट. सो this is the concept of the baler, belly, and bailment. Next, once the purpose is done, the belly must return the goods or deal with them as instructed by the baler. अगर जिस इंटेंशन के लिए, जिस रीजन के लिए उस सामान को पहला इंसान से लिया गया है, बेलर जिस रीजन के लिए अपना सामान दिया है, once that purpose is been completed, once that intention is being completed, then the belly जिसको सामान दिया गया है, he or she must return the goods, वो गुड्स को क्या करेगा, वापस करेगा. The belly must return the goods, वो गुड्स को किसको रिटर्न करेगा, he will return the goods to the bearer. वो किसको रिटर्न करेगा, बेलर को रिटर्न करेगा. कौन रिटर्न करेगा, बेली रिटर्न करेगा. कब रिटर्न करेगा, जब सामान का जरूरत खत्म हो जाएगा या फिर द ड्यूरेशन फॉर व्हिच द or the purpose for which the thing has been given, it has been completed. Okay, just take an another example of this. You know about the drivers, वहां पे क्या होता है, कपड़ों का ड्राई क्लीनिंग होता है, राइट? Just take an example that you have given your clothes to the dry cleaner for the purpose of cleaning. You are using the shoes, okay? So you have given your shoes to the baler. You have given your shoes to the belly for the purpose of cleaning. आपका जो शू है, आप कोई दूसरे इंसान को क्लीनिंग का पर्पस के लिए दे रखे हैं, है ना? या फिर वो कोई शॉपकीपर हो या कोई दूसरा इंसान हो, यू हैव गिवन योर स्पेसिफिक थिंग टू ए स्पेसिफिक पर्सन फॉर ए स्पेसिफिक पर्पज. यहाँ पे इफ यू आर द बेलर, जो दिया है, मतलब यहाँ पे कौन दिया है, आपने दिया है. यू आर द बेलर ओवर हियर. एंड किसको दिया है, आपने शॉपकीपर को दिया है, ड्राई क्लीनर वाले को दिया है फॉर द पर्पज ऑफ क्लीनिंग. सो दैट पर्सन इज कॉल्ड एज द बेली. जो दे रहा है उसको बोलते हैं बेलर, एंड जो ले रहा है उसको बोलते हैं बेली. जैसे कि मैंने बताया, ड्राई क्लीनर हो गया, आपका जूता साफ करने के लिए आप दुकानदार को, मोची को आपका जूता दे देते हैं. तो दीज आर द कॉन्सेप्ट ऑफ द बेल, जहां पे आप क्या करते हैं ना, एक स्पेसिफिक पर्पस के लिए अपना यूज्ड इंस्ट्रूमेंट जो है, अपना यूज्ड गुड्स जो है, वो एक दूसरे इंसान को ट्रांसफर करते हैं, देते हैं. वो दूसरा इंसान क्या करता है, उस चीज को सही ढंग से, सही तरीके से, जिस पर्पस के लिए आपने दिए हैं उसका काम कर देता है. इधर आप अगर कपड़ा साफ करने के लिए दिए हैं तो कपड़ा साफ कर देता है, अगर आप जूता साफ करने के लिए तो जूता साफ कर देता है. एंड once the thing is being cleaned, the specific goods must return to be you. एक बार हो जाता है तो वो स्पेसिफिक गुड्स, स्पेसिफिक जो सामान है उसको रिटर्न कर देना चाहिए. हो गया. Then this is about section 148, where we have understood that what is the concept of the bearer, the person who gives the goods, the person who gives his specific good for the specific intention, the belly who receives or who takes the goods, and third, the bailment. This whole process of transferring one specific thing to another, that is called the concept of the bailment. Okay. So under this concept of the bailment, under section 148, we have understood what is the concept of the bailment, who is the bailer, and who is the bailee. We have discussed it. Then comes your section 149. And this exactly speaks that how is the delivery of the belly is being done. Okay, अगर एक बेली है, उसको कोई सामान डिलीवरी किया जा रहा है, then how the delivery to the belly is being done. बेली को उस सामान का, उस स्पेसिफिक गुड का डिलीवरी किस तरीके से होगा. This is explained under section 149 of the Indian Contract Act. Okay. So when we are talking about the delivery to the belly, it means delivery happens when the goods are given to the belly or to someone authorized to receive them on behalf of the belly. What does it mean? It means that delivery happens. The delivery of the goods happens when the goods are given to the belly or someone authorized to receive them on behalf of the belly. Okay. That means अगर मैं बोलती हूँ कि मैं आपको एज ए bailment as a belly, and you are the belly and I am the bailor, and I have done the transfer of the bailment. ये जो बेलमेंट का पूरा प्रोसेस है वो कब तक ट्रांसफरेबल है, वो है जो माना जाएगा. दिस मीन्स दिस होल प्रोसेस ऑफ द बेलमेंट व्हेन इट विल बी कंसिडर्ड एज बीन कंप्लीटेड. ये चीज कब माना जाएगा कि ये जो प्रोसेस ऑफ द बेलमेंट है ये खत्म हो गया करके. When the one thing is being transferred from one person to another. जब कोई भी किसी भी तरीके का डिलीवरी होता है, डिलीवरी हैपेंस व्हेन द गुड्स आर गिवन टू द बेली. डिलीवरी कब कंप्लीट किया गया करके माना जाएगा? जब कोई सामान या फिर कोई गुड्स बेली को पूरी तरीके से दे दिया जाएगा. when the belly receives the specific goods, okay, and someone authorized to receive them on behalf of the belly. या तो बेली के तरफ से कोई भी उसका रिप्रेजेंटेटिव हो, कोई दूसरा इंसान हो, he or she has received the same property. Either the belly has received the same property or or any other person who is authorized by the belly has received the same property. अगर यहाँ पे ये दोनों condition होता है, then this whole process of the bailment is considered to be completed. Okay. According to under section 149, we clearly discussed that how the delivery of the belly is done. And under this concept, we have already discussed that when we are talking about the delivery of the goods by the bailor to the belly, it means the delivery happens when the goods are given to the belly or someone authorized to receive on behalf of the belly. Either बेली को खुद को ये प्रॉपर्टी ट्रांसफर किया जा रहा है, या any other person on behalf of the belly is receiving the property, receiving the specific good, then in that circumstances also the transfer is considered to be completed in nature. Got it? Then comes section 150. What does it mean? It speaks about the bailor's duty to disclose the facts. Okay. So when we're talking about the duty of the bailor to disclose the fact, that is explained under section 150, and it exactly speaks that, just let's read the section once. Bailor's duty to disclose faults in goods belief. Okay. The bailor is bound to disclose to the belly faults, means mistakes in the goods belt, of which the bailor is aware and which materially interfere with the use of them or expose the belly to extraordinary risk, and if he does not make such disclosure, he is representative for damage arising to the belly directly from such faults. Okay. If such goods are billed for hire, the bailer is responsible for such damage, whether he was or was not aware of the existence of such faults in the goods billed. Okay. So when we're talking about the bailer's duty to disclose the faults in goods believed. Okay. So when we're talking about the faults in the goods, agar there is the specific transfer of the property or transfer of the specific good from one person to another, यहाँ पे अगर एक इंसान दूसरे इंसान को एक स्पेसिफिक तरीके का गुड का ट्रांसफर कर रहा है and that property is immovable in nature, so this is the basic duty or responsibility of the bailee to disclose the faults. जो चीज का डिलीवरी दिया जा रहा है, द थिंग विच इज बीन डिलीवर्ड, हाउ फार इट इज रिलेवेंट, उसका रिलेवेंसी क्या है, इज दैट प्रॉपर्टी इज एक्चुअली रिलायबल टू बी ए प्रॉपर्टी टू बी डिलीवर्ड. These things needs to be clearly taken care of. So it is the duty of the bailor जो अपना सामान दे रहा है टू डिस्क्लोज द फॉल्ट्स ऑफ द स्पेसिफिक थिंग, कि ये चीज में क्या क्या फॉल्ट है, उस चीज को क्लियर करना बहुत जरूरी होता है. गॉट इट? एज वी हैव अंडरस्टूड अबाउट द bailor's duty to disclose the faults under which we have discussed, that the bailor must be the bailee about any known faults in the goods and adult. Okay. And point number one, it speaks about the interference with the belly's use of the goods or exposes the belly to risk or harm. This is all explained under section 150 of the Indian Contract Act. Okay. So when we're talking about the bailor's duty to disclose faults, according to section 150, what does it mean? The bailor must tell the bailee about any known about any known faults in the goods that could interfere with the bailee's use of the goods or exposes the bailee from risk of the harm. Okay. So when we're talking about the this is the problem with disclosing the faults of the specific thing, but you have to disclose it to the bailor itself. ये चीज बेलर को एज ए बेली, इट इज बेसिक रिस्पॉन्सिबिलिटी ऑफ योर्स टू डिस्क्लोज द फैक्ट्स टू द बेली. ओके. So when we're talking about, if the bailor does not inform, then what will happen? The bailor will be responsible for any kind of the losses or injury caused. And it is the last point, that if it's a paid bailment, like the hiring car, then the bailor is responsible for guys even if they do not know about them. Got it? Section 150, just like let's have a short glance on this. The bailor must tell the bailee about the known faults in the goods that would interfere with the bailee's use of the goods or expose the bailee to risk the harm. Okay. So when we are talking about the bailor's duty to disclose the facts, under that we understood that it is the duty of the bailor to disclose the faults of the goods in the specific thing or specific property or specific good which has been given. Okay. And that could interfere with the bailee's use of the goods and exposes the belly to risk them. What is the first point? To interfere with the belly's use of the goods. अगर ऐसा कोई fault है in the specific good which has been given, for which the specific purpose of the good cannot be fulfilled. For example, I am giving you this watch for the purpose of repairing the watch, okay? And I know you are a person who is repairing this in a very better way. So I have given you on a trust, okay? But just take an example. There is a defect in the watch. जितने भी बार इसको सही कर लो, जितने भी बार इसको ठीक कर लो, इसका ये जो खराबी होता है ना, ये बार बार ठीक होता ही नहीं है. So you are giving this watch to another person. You are not giving this watch to the मतलब दुकानदार. You are giving this watch to another person for the specific purpose. Okay. Specific purpose means for example there is a friend of mine जिसका एग्जाम है, तो मैंने क्या किया, उसको अपना वॉच दे दी. Because that person is going to the examination also, that person might need the watch, so I gave the watch to the specific person. Okay. So when I am giving my specific good to the another person, okay, then in that specific circumstances, it is the bearer's duty to disclose the situation, okay, and disclose the faults that has been associated in the bailment property. Got it? Then comes section, and under the same section we have other two clauses also. If the bailer does not inform, the bailer will be responsible for any loss or injury occurred. If the bailer did not offer anything, okay, in that specific circumstances, when there is the bailer who has not informed any specific thing to the bailee, then the bailer will be responsible for any kind of the losses or injury occurred. That means अगर यहाँ पे मेरे को, मैं अपना ये जो, for example I am having a mobile phone and I am giving you that mobile phone for the purpose of using it. आपके पास कोई फोन नहीं है, मेरे पास दो फोन है, तो मैंने क्या किया, अपना फोन आपको कुछ दिन के लिए दिया to use it for the specific purpose of the calling. Okay, got it? So when I am giving you my thing for the specific purpose, okay, then in that specific circumstances, if we are talking about the bailer has not informed the bailee about the faults associated in the goods, then what will be the circumstances? Then in that circumstances, the bailer is liable. It is mandatory for the bailer to bear the losses or damages occurred, and the bailer is here mandatorily have to compensate the bailee for the losses or the damages occurred, for the injury caused. And if it is the paid bailment, like hiking a car and all these things, then in that circumstances, the bailer is responsible for the faults and even they do not know about them. Okay. So when we're talking about if it is the paid bailment means, for example, I am giving you my watch for the purpose of repairing, and as you are taking care of my property, as you are repairing my watch, or you are doing hard work for me, so there is the specific payment is been associated with this task. This is called the paid bailment. Okay, and the bailer is responsible for the faults even they do not know about them. Okay, and here in these circumstances it is the major duty of the bailer to disclose the faults associated with this, and with the certain circumstances, if it is proved that and in the certain circumstances, if it is proved that it is the paid bailment and the bailer is responsible for the faults even if they do not know about them, That means even if the buyer has no idea about the specific issue in the property, then also the buyer is liable for the specific activity. Just take an example of this. You are traveling from one place to another. So we we book a cab in this online platform and online systems. Okay. So when we uh, do this on the online systems, okay, um, this is the when we book a cab for ourselves. During our booking of the cab or booking of the specific bike or anything, Ola bike, Ola cab, Uber bike, we used to book this for the anajana purpose. Okay. So during these circumstances, we have understood this, that when you are booking a cab, that means this is the responsibility of the company to make assure that you are reaching your place in a successful and proper manner. Okay. So when we are talking about this, it means this is the duty of the builder to take care of the belly, that how the belly is dealing with the property. So here under section 150 it is explained that the builder is responsible for the faults even if they don't know about them. For example, when we are hiring a car for the traveling purpose, I'm staying at the location of Odisha, and I'm hiring a car to travel to a specific area. Okay, so when I'm booking a car, this is also a kind of the bailment, because here the car owner is the bailer and I am the bailee. That person has just given you the thing, and after that I became the and in return, that person, this is a paid bailment. I am paying something to that specific person for that specific property. That person has sold me his car, and in return I had to pay him certain specific amount. Okay. So when it is the paid bailment, like hiring a car, when you are hiring a car for the specific purpose, then in these specific circumstances, who will be responsible? The bailer will be responsible if there is any kind of the damage or loss happening to the another person. If there is any kind of the loss or damage or any kind of the injury is happening to the front person, then in these circumstances the bailer is fully responsible for the whole act, and it is immaterial that whether the bailer had the idea about this on a primary note or not. ये फर्क नहीं पड़ता कि बेलर को ये चीज का ये डिफेक्ट के बारे में पता था या नहीं था. दिस डज नॉट मैटर. व्हाट मैटर्स कि बेलर जो है उसी ने सही तरीके से एक्ट नहीं किया, एंड दिस हैपेंड ड्यू टू द नेग्लिजेंस ऑफ द बेलर. ओके. सो व्हेन द बेलर does not inform about the defect of the bailed property, he or she is wholly responsible for the losses or damages occurred that we discussed. And if it is a paid bailment, अगर ये चीज बेल करने के लिए पेमेंट किया जा रहा है, for example, hiring a car, when I am hiring a car from traveling one place to another, and the person who has given the car to me, he has the idea that the car is having defect with the brake system, and due to which I met an accident due to the unavailable brake system of the car. So in these circumstances, the person who is the bailer has to compensate me the full amount of for my recovery. But take an example that in this paid bailment, like when I have hired a car, I have no idea what to do. Okay, like I didn't know that there is the any issue with the brake system of the car or anything. I just saw that there is a booking for the hiring of a car. The person has given me the advance and I sent the car. Even as the owner of the car, I have no idea that the car has held the brake system. But due to this, the accident happened. Then who is the owner of the car? Obviously, the bailor, the owner. And here, even if the owner has no idea or no intentional damage occurred by the bailor, यहाँ पे bailor जो है उसी को कोई ये आइडिया नहीं था कि ये चीज होने वाला है, एंड उसी का ये जो एक्टिविटी है दिस वाज नॉट इंटेंशनल इन नेचर, उसको पता नहीं था कि ये चीज आगे जाके ये कंसिक्वेंसेस करेगा कि उसी का क्लाइंट का एक्सीडेंट हो जाएगा, बेली का एक्सीडेंट हो जाएगा ड्यू टू द ब्रेक फेल. He was even himself unaware about the brake fail. And in that circumstances, if it is the paid bailment, the bailor is responsible for the faults. Even if the bailor has no idea about it, even if bailor को ये चीज नहीं पता है कि what is the reason of the even if it is not been informed to the bailor को ये नहीं पता है कि there was any kind of the fault in his property or in his good, still the bailor is responsible for the faults. Okay, then comes your section 151, and it speaks about the bailie's duty to take care of the goods. Okay, so when we're talking about the bailie's duty to the take care of the goods, it is explained under section 151 of the Indian Contract Act. Okay, so what does it mean? The bailee must take care of the goods as an ordinary careful person would have take care of their own goods of the similar nature. According to section 151, this exactly speaks about a very interesting factor. What is it? When the bailee is accepting a specific kind of the goods from the bailor, मान लो I am the bailee over here and I am accepting a good from the bailor, okay, then it is fixed that the bailee must take care of the goods as an ordinary careful person would take care of their own goods on a similar nature. अगर मैंने आपको मेरा घड़ी एज द एग्रीमेंट ऑफ द बेलर एंड द बेली, मैंने आपको अपना घड़ी दिया है फॉर द रिपेयरिंग पर्पज, तो आपको घड़ी का उतना ख्याल रखना होगा जितना घड़ी का ख्याल मैं खुद रखती. अगर घड़ी मेरे पास रहता तो मैं घड़ी का जितना ख्याल रखता, अगर घड़ी आपके पास रहता है तो आपको भी घड़ी का उतना ख्याल रखना पड़ेगा. For example, I have given you my clothes for the purpose of dry washing. So if the clothes would be with me, अगर वो सारे कपड़े मेरे साथ होते, मेरे पास होते, तो उसको मैं जिस तरीके से संभाल के रखती, इट इज योर रिस्पॉन्सिबिलिटी टू टेक केयर ऑफ दैट. आपको भी उस सामान को उसी तरीके से संभाल के रखना पड़ेगा. So this is about section 151, very easy in nature. The bailee must take care of the goods as an ordinary careful person. This is important. Bailee will take care of the goods as what? As the ordinary careful person. जैसे कि there is a person who is careful in nature and the ordinary careful person, the way he takes care of his own goods as the owner of the property or owner of the good, the another person to whom he is giving the property or giving the specific good or specific instrument as the agreement of the bailment, that second person or the bailee has to take care of of, of the specific good as if it is the own good of the specific person. अगर मैंने आपको अपना घड़ी दे रही हूँ फॉर द रिपेयरिंग पर्पज, अपना मोबाइल दे रही हूँ फॉर द रिपेयरिंग पर्पज, अपना कपड़ा दे रही हूँ फॉर द ड्राइवर्स पर्पज, अगर वो कपड़ा मेरे पास रहता, अगर वो घड़ी मेरे पास रहता तो उसको जितना ख्याल रखना होता आपको भी मेरा सामान का उतना ख्याल रखना पड़ेगा. दिस इज इजीली एक्सप्लेन्ड अंडर सेक्शन 151. गॉट इट? Then comes your section 152. What does it mean? It speaks when is the bailee not responsible for loss of the goods. Okay, what does it speak? If the bailee takes proper care as described in section 151, they are not responsible for the loss, destruction or damage of the good. अगर कोई नेचुरल कैलामिटीज आ जाता है जिसके वजह से बेलर का जो सामान है उसी को किसी भी तरह का नुकसान पहुंच जाता है. फॉर एग्जाम्पल, द बेलर हैज गिवन ए स्पेसिफिक मोबाइल टू द बेली फॉर द पर्पज ऑफ रिपेयरिंग इट. द बेली हैज टेकन केयर ऑफ द मोबाइल एज इफ इट इज तो ओन गुड. उसने मोबाइल का बहुत ख्याल रखा, उसी को सही ढंग से संभाल के भी रखा है. बट अनफॉर्चुनेटली ड्यू टू सर्टन सर्कमस्टांसेस, यहाँ पे पानी आ जाता है, बारिश हो जाता है, कोई भी दिक्कत हो जाता है, कोई नेचुरल कैलामिटीज आ जाता है जिसके वजह से वो जो मोबाइल फोन है ना वो खराब हो जाता है, उसका सही ढंग से ख्याल नहीं रखा जाता. सो हियर the belly is not responsible for the loss or destruction here because he has taken the proper care of the property of the good. वो जो सामान है उसी ने अपना ड्यूटी अच्छी ढंग से कर चुकी है, अच्छी ढंग से कर चुका है. उसने वो सामान को अपना सामान जैसा उतना ही ख्याल से रखा है विथ ए गुड कंसर्न. बट ड्यू टू द अनअवॉइडेबल सर्कमस्टेंसेस, अगर उस सामान का, उस स्पेसिफिक गुड का किसी भी तरह का नुकसान होता है, देन द बेली इज नॉट रिस्पॉन्सिबल फॉर द लॉस, डिस्ट्रक्शन और डैमेज ऑफ द गुड्स. इस उसी केस पे, उसी मामले में बेली जो है उसको उस स्पेसिफिक सामान का लॉस, डैमेज और डिस्ट्रक्शन का भरपाई नहीं करना पड़ेगा. So this is up to section 152 guys. उसके आगे जो section है we are going to discuss in the next class. This is all for today. We are ending the class here. Thank you. Bye bye. Take care.